Last month, a client walked into my office devastated. Her father passed away, leaving a $2 million estate, and she was facing 18 months of probate and $150,000 in legal fees and a family feud that could have been entirely avoided with one simple document. Can you guess what that is? I'm Santiago Cueto, a board-certified international business law expert and best-selling author, and I've helped thousands of families navigate Florida's complex estate planning landscape. Today, I want to share with you the most important decision Florida property owners face. When should you put your property into a trust? This decision can save you thousands of dollars, protect your family from lengthy legal processes, and ensure your wishes are carried out exactly as you intended. Now, Florida offers unique advantages for trust planning that many other states simply don't provide. We have no state income tax, which makes Florida an attractive state for trust beneficiaries. And most importantly, Florida has specific laws that make trust particularly powerful tools for property owners. Now consider this scenario. You own a beautiful home in Naples worth $800,000, and you want to ensure it passes smoothly to your children when you're gone. Without proper planning, your family could face months or even years of probate court proceedings, during which they cannot sell, refinance, or fully control that property. The probate process in Florida typically costs between 3% and 8% of the estate's value. On an $800,000 home, that's potentially $24,000 to $64,000 in fees and costs that could have been avoided entirely. Now, let me share the most common situations where putting Florida property into a trust is not just beneficial, but essential. Now, if your primary goal is to ensure your property passes quickly and privately to your beneficiaries, a revocable living trust is often your best option. In Florida, probate can take anywhere from 6 months to several years, depending on the complexity of the estate and whether anyone contests the will. Now, during this time, your property is essentially frozen. Your heirs cannot sell it, rent it out, or make major improvements. They're stuck maintaining and paying taxes on property they cannot fully control. Now, with a properly funded trust, your property can transfer to your beneficiaries immediately upon your death without court involvement. This is particularly crucial if you own rental properties or commercial real estate that generates income. Your beneficiaries can continue collecting rent and managing the property without missing a beat. Now, if you own property in Florida but live in another state, a trust becomes even more important. Without one, your heirs may face the nightmare of ancillary probate, essentially having to go through probate proceedings in both your home state and in Florida. This doubles the time, complexity, and cost of settling your estate. Now, for blended families, Florida's elective share laws give surviving spouses significant rights to claim a portion of the deceased spouse's estate, even if the will says otherwise. Now, if you're in a second marriage and want to ensure your children from your first marriage receive your Florida property, certain types of trusts can help you navigate these complex family dynamics while still providing for your current spouse. Now, while Florida offers excellent homestead protections for primary residences, this protection has limitations and doesn't extend to all property types. Now, if you're a business owner, professional, or anyone facing potential liability issues, moving property into certain types of trusts can provide additional layers of protection. Florida's asset protection trusts, when properly structured, can shield assets from future creditors while still allowing you to benefit from the property during your lifetime. The best time to establish a trust is now, while you're healthy, mentally sharp, and not under any pressure. Now, here's why timing matters so much. To create a valid trust in Florida, you must have mental capacity. If you wait until you're facing serious health issues, you might lose the opportunity entirely. I've seen too many families struggle because a loved one waited too long, and by the time they wanted to create a trust, questions about their mental capacity made it impossible or created grounds for future challenges. Current federal estate exemptions are historically high, over $12 million per person in 2023. However, these exemptions are set to be cut in half in 2026 unless Congress acts. Now, if you have substantial Florida real estate holdings, transferring property to irrevocable trusts can now lock in current valuations and exemption amounts. Florida's real estate market has seen tremendous appreciation in recent years. If you believe your property values will continue to rise significantly, transferring property to an irrevocable trust now can freeze the value for estate tax purposes while allowing future appreciation to benefit your heirs tax-free. Now, not all Florida property is the same, and different types require different approaches. Your Florida homestead receives special constitutional protection, but these protections end at death. For married couples, properly structured trusts can preserve homestead protections for the surviving spouse while ensuring the property ultimately goes where you want it to go. Rental properties and commercial real estate are excellent candidates for trust ownerships. Unlike your homestead, these properties don't receive special constitutional protections, making trust planning even more crucial. Now, a trust can also simplify management if you become incapacitated, allowing your successor trustee to continue collecting rents and maintaining properties without court intervention. Now, if you own undeveloped land in Florida that you expect to appreciate significantly, transferring it to a grantor trust now can remove future appreciation from your taxable estate while allowing you to retain significant control during your lifetime. Now, trusts aren't always the answer. If you're struggling financially, have significant debts, or your total estate is relatively modest, the cost of establishing and maintaining a trust might outweigh the benefits. Similarly, if you're young, single, have no children, and own only modest assets, a simple will might suffice for now. However, remember that circumstances change. Many people who don't need trust today will need them in the future as their wealth grows, their family situations become more complex, or they acquire additional Florida properties. If you're convinced that a trust makes sense for your situation, don't delay. Start by gathering information about all your Florida properties, deeds, mortgages, tax records, and current valuations. Then consult with a qualified Florida estate planning attorney who understands both trust law and Florida real estate law. Remember, creating the trust is only half the battle. The trust must be properly funded by transferring your property deeds into the trust's name. An unfunded trust is like a beautiful empty container. It won't help you achieve your goals. In conclusion, putting your Florida property into a trust isn't just about avoiding probate or saving money, though those benefits are substantial. It's about taking control of your legacy and ensuring that everything you've worked to build will benefit the people you care about most, exactly as you intend. Don't let your family become another cautionary tale. If this video helped you understand when trust makes sense for your Florida property, hit that like button and subscribe to my channel for more essential legal insights that can protect your wealth and your family's future. I'll see you in the next one.